Hello friends, Namaskaram, Har Har Mahadev Shivisham. With the blessings of Almighty, we are going to discuss an important topic concerning the prevention of corruption act in the present class. Do you know the importance of a valid sanction? If you know, then it is good. But if you are not knowing, then the present class is too much helpful for you. Do you want to update your knowledge or information on the subject? And for doing this, I request all of you at the inception to maintain a proper notebook with pen or pencil so that whatever I am going to narrate you could be maintained by you in recorded format so that in near future you are having a trouble without getting any worry or panic. You could easily contest the same on merits. But for this, information or knowledge is sine qua non. First of all, we will discuss the basic problem and then we will discuss how to deal with the problem so that we could have a proper solution on board. It is a basic mythology of us. If we are not having a solution, then we are the biggest problem. Now it depends on you whether you want to become a part of solution or a problem. I know that you want to be the part of a solution. The problem is, suppose you are a public servant. You are the part and parcel of a selection committee. Ultimately, it is found that who are eligible are not selected and who are ineligible are selected, and the entire committee, including you, are prosecuted under Prevention of Corruption Act. What you will do? Simply, you will take the copy of FIR and would go to an advocate for the purpose of consultation and regarding the further step to be taken in the case. Either you may plan for anticipatory or for question. But do you know you're going to play with your life and liberty and with your services as well? Because moving for anticipatory or for question is a solution, do you think? I think that if you are moving ahead, there's a need of proper strategy. There's a need of proper review so that we could be on the right track in the legal sense. So the primary key is that we have to observe on what basis the FIR had been registered, and apart from that, the legal compliances are done or not. And despite of that, if there is a charge sheet, we have to consider the point of sanction as well. Whether the appropriate sanction is put on the record or not. If all the criteria are not fulfilled in that scenario, it is a time to review, have to find out the legal point, and it is a time to move for questioning so that we could have better results on board and could have a secure questioning order in our favor. But before moving the same, we have to understand the certain points. So it is clear to us what the problem is. Now we are coming on solution. To do this, I request you, first of all, you are required to write down the citation title, that is Amit versus State of UP, and it is pronounced by Honorable Allahabad High Court on 30th of June 2024. In that case, the accused person was prosecuted under Prevention of Corruption Act and he was charged with Section 13 Subclause 1 Subclause D of PC Act. He was charged for appointment scam. The allegations are that being the member of selection committee, he selected those who are ineligible, and that's why the entire committee played with the future of eligible students. While challenging the entire FIR, the concerned accused submitted that I had done nothing. And apart from that, entire allegations are false, fabricated, misuse of process, and on mere surmises and conjecture, the prosecution brought the present prosecution against him. He submitted that bringing criminal law into motion is a serious concern. It affects the life and liberty of the accused. And the said version is quoted in the light of judgment of Honorable Supreme Court. And apart from that, he submitted that the investigation is not done in the fair manner. And on the point of unfair investigation, he challenged the proceedings as well. He submitted that during the course of investigation, I had submitted certain points to the IU, which were not considered. The points are: It is true that I am part and parcel of selection committee, and you might have the resembling case of yourself. He submitted that there are certain protocols in the selection. Protocol number one is typing, and number two is interview. He submitted that I have no role in conducting the typing test. This is a primary test to be conducted before going for the interview process. Apart from that, I am having no role to decide the qualification of the concerned candidate. And apart from that, the interview is conducted as per the protocol of direct recruitment for the Group C post as per the rules and regulation, and the typing protocol is governed by Directorate of Technical Education and Employment and Training Department, which is at Lucknow. So basically, I have conducted the interview which is as per the protocol. I have nothing to decide the qualification regarding the concern of the typing test. And he submitted that I am having a good service record, having no criminal antecedent, and apart from that, there is no valid sanction on record which is required as per the protocol of Section 19 of Prevention of Corruption Act. He submitted that in the present case at hand, the cognizance is taken on the basis of a sanction that is totally invalid, vitiate the proceeding because it is in the printed performer, which is not permissible in the eye of law, because it indicates the non-application of mind. He submitted that the purpose of prosecution sanction is to provide the safeguard to the concerned public servant against the unwarranted prosecution. The same is sine qua non, and apart from that, it could not be a mere formality. He submitted that he is having no specific rule, and the sanction is itself indicating that it is cyclostyle, and also indicating that there is no application of mind because in the printed performer it is given. The consent sanction itself shows that there is application of mind, and if there is no application of mind, it vitiates, as observed by Honorable Bombay High Court as well. He submitted that the fair investigation is a fundamental right of the accused, and I had submitted certain points to the investigating authority, but despite of that, the concerned investigating authority has shown no concern regarding the same. He submitted that the investigating authority have to do multiple tasks to have a proper charge sheet. Number one, verification of report. Number two, FIR. Number three, moving on a spot to collect the material evidence. Number four, preservation of evidence. Number five, analysis. And number six, the compliances. And number seven, the charge sheet. But all the said protocols are not followed in the present case as well. Apart from that, the printed performer sanction are not allowed as observed by Honorable Supreme Court in Caton of Judgment. And the important judgment concerning the same are as under. Number one, Bhushan versus State of NCT. Citation is EIR 2012, Supreme Court, page 1747. In addition to this, the judgment of Sunil versus CBI, citation is EIR 2015, Supreme Court, page 923, is also important on the point. And apart from that, judgment of Lallan Kumar versus State of Maharashtra, that is 2022 SCC online, page 1383, are also important on that point. So it is clear to us that if sanction is cyclostyle, it is indicating non-application of mind, it vitiates the proceeding, and we could challenge the same without getting any worry or panic. So the present judgment inter alia enlighten us with 5 important points to be remembered. Number one, whenever there is a FIR against us concerning section 13, subclause 1, subclause D of PC Act, do not be panic. Read the FIR and submit your objections, means the reply, that is usually called the representation. Number two, do not be in a panic to move for anticipatory or questioning proceeding. Review the entire FIR and submit your objections. Number three, if charge sheet is filed despite of the objections, in that scenario, you could challenge the proceeding on ground of unfair investigation. Number four, you have to observe the sanction order as well. If it is cyclostyle, indicating non-application of mind, or it is in the printed performer, then you may challenge the proceedings of sanction on the ground of it is not a valid sanction. And apart from that, to challenge the same, you need to draft the proper petition. Apart from that, while drafting the petition, first narrate the FIR. Number two, shortcoming of the FIR. Number three, the true position. Number four, your stand. Number five, the submissions made by you. Number six, the non-consideration. And number seven, the legal position and compliances. And in the last, you have to submit your prayer. So in that format, you have to proceed. So I think that I'm totally able to cause all of you to understand the basis of sanction order and how to challenge the same, and what are the remedies available at law with the legal positions as well. See you in the next video. Till then, Jai Hind, Jai Bharat.